don't group.
No.
Or Ms. Rosa showing that I would have stipulated that.
There was no stipulation to that.
No, not, okay. It's a big truck.
I know.
He got there's not a single violation. He'd stay away. Well,
I know. However, court calls case People versus Rebecca Valentine.
Good morning, Your Honor. First, Lena Anderson with and on behalf of Ms. Valentine. Ms. Valentine, please state your name.
I'm defending myself, Rebecca Valentine, and I want to enter a guilty plea.
Excuse me?
Your Honor, I spoke with her this morning. She advised me that she wanted to represent herself and did not wish to be represented by the public defender's office.
Is that a correct statement, ma'am?
Yes.
All right. Couple things we have to do here then. I do have to advise you that you are before the court on 2 charges of assault on a prison employee. Do you understand the nature of those charges?
Yes, they started it, but I ended it, and I'm guilty, and I want to say I'm guilty.
Ma'am, I'm also going to advise you that you should refrain from saying anything about the offenses, as anything that you say can be used against you in this matter. You also understand that each of these counts is a felony, punishable by up to 5 years incarceration and a $250 fine plus court costs. You understand that?
Yes, I do understand that.
All right. You also understand that there can be great perils in representing yourself in this matter?
Yeah, but I accept that. I don't really think there's that many perils.
You also understand that in doing so, that you would be held to the same standard that an attorney would be held to regarding knowledge of the court rules and knowledge of the proceedings.
That sounds pretty fair.
All right. So your intention is to represent yourself in this matter?
Yes, sir. And plead guilty right now.
You understand, you could please not interrupt me, but if you understand also that if at any time during these proceedings that you wish to be represented by counsel, that you can request that of the court, and the court would appoint counsel to represent you if you could not afford to hire counsel. You understand that, ma'am?
Yes, sir.
And so you wish to proceed today without counsel, is that correct?
Yes.
Public defender is permitted to withdraw as counsel of record, defendant to represent herself.
Thank you, Your Honor. Do you need an order?
Pardon?
Do you need an order?
Please.
I'll get that to you right away, sir.
Okay, ma'am, what do you wish to do today?
I would wish to enter a guilty plea.
All right. If you wish to enter a guilty plea, you're going to have to waive your right to a preliminary examination, proceed to circuit court, and enter the guilty plea there.
Okay.
So you wish to waive your right to have a preliminary examination in this matter?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Ma'am, you understand, and it has not changed from the time of your arraignment to the time that I had just read the charges. You understand that this is, at this point, the circuit court arraignment. You understand that, ma'am?
Yes, sir.
The information in this case alleges that on or about November 26, 2022 at Huron Valley Correctional Facility, count 1 alleges that you did commit an assault on a prison employee, that being a Tracy Maupins. You understand that charge?
Yes, sir. I punched her in the head 3 times.
Excuse me?
Yep, I did it. I punched her in the head.
Well, you understand what you are charged with.
Yep, punching her in the head.
It's a felony punishable by up to 5 years incarceration and a $2,500 fine plus court cost. You understand that, ma'am?
Yes, sir.
The information also alleges that on that same date at that same location, that you did commit another offense of assault on a prison employee, that being a Lauren Hales. You understand that charge, ma'am?
Yeah, I punched him in the head 3 times too.
I'm also going to advise you that you should refrain from saying anything about the offenses in this case, because anything you say can and will be used against you. You understand that, ma'am?
Yeah, but I'm already saying I'm guilty, but I understand.
The second offense is also a felony punishable by up to 5 years incarceration and a $2,500 fine plus court costs. You understand that?
Yes, sir.
You also understand that, as I had indicated before, that you do have the right to be represented by counsel. You cannot afford to hire counsel. You would be appointed counsel to represent you. You understand that?
Yes.
This time, ma'am, what I'm going to indicate is that you're standing mute to these charges. That means you're not at this time saying anything about them, and I will be entering a not guilty plea. You understand that?
No, because I want to say I'm guilty. And I
And
thought we
you
found
said
it
it-
over to
you
circuit
said
court,
it all
so I,
Ma'am, you understand that for the purposes of this arraignment, you're not saying anything about them, meaning that you're standing mute. By law, that means that the court will enter a not guilty plea on your behalf. You will proceed to circuit court and then you will do what you wish.
oh, I thought we just switched over to circuit court so I could do that.
Well, we kind of did. But I'm
So I
not
don't
doing the plea. The fact that you don't understand may be why you need an attorney.
I
But
don't need an,
I can't force you to have one, so you're going to proceed on your own. Do you understand what I have just said?
yep, you're not doing what I said.
Court will indicate the defendant is standing mute to both charges. I'll enter a not guilty plea. Pre-trial in this matter will be set for. Good luck. November 13th, 2024, 1:30 before Judge Conlon, and I'm sure Judge Conlon will be more than happy to take your guilty plea, ma'am. All right?
Okay.
Bond in this
Have a good
matter
day.
will continue. Thank you.
Thanks.
Court calls the case, People versus Noah Adamson.
Michael Vincent on behalf of Noah Adamson.
Excuse me one moment. Ms. Anderson, thank you for all the help on that. You got away from that podium faster than I've ever seen you move. All right. I'm sorry, Mr. Vincent, go ahead, sir.
Michael Vincent on behalf of Noah Adamson. Mr. Adamson, put your name on the record.
Noah Adamson.
Thank you. And you are requesting an adjournment, is that correct? How much time do you need for discovery?
I think we need a waiver. We're going to waive this to circuit court after conference with Ms. Blanch.
You didn't even, you're gonna waive?
Yes, I just got done talking with the prosecutor, and I think we can resolve this. in circuit-
Who's here with you?
Where's my keeper?
Okay, because you filled out the form. I know, because this is not his writing. But, okay, because I can read it. Sir, you wish to waive your right to a preliminary examination.
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 and 4 following. Mr. Vincent, you waive formal reading of the information, stand mute.
Yes, Your Honor. Thank you for helping.
Defendant having waived formal reading, standing mute to all 4 charges, court will enter a not guilty plea.
Yes, sign right here.
Pre-trial in this matter, November 5th, 2024, 1:30. Bond will continue. Thank you, Mr. Vincent.
Thank you, Your Honor.
Court calls the case, People versus Clinton Berry.
Your Honor, Michael Vincent on behalf of Clinton Berry. Mr. Berry, put your name on with the judge.
Clinton Berry. Thank you.
Your Honor, we need a date. Two things I want to raise, because I know you want to remind me, but I remember. He has a GPS tether on.
He does.
And last time we were here, Your Honor said if everything's copacetic, he can take it off. And
I
I
don't know
think
that I said that.
he's an over-the-road truck driver. He goes to different states.
Is there going to be any objection from the people?
Your Honor, this is a DV case. I think a GPS tether is standard. I do not know that I was present for his left.
You weren't, but Ms. Barroso was.
I don't recall.
No.
I don't think it's my own or Ms. Rosa's
Okay.
showing that I would have stipulated that.
There was no stipulation to that.
No, but
There
you
was
would
no
look
agreement.
at, no,
I would
I
look at
understand,
it.
but you would look at it. There's been no violations of the tether at all since he put it on. He has,
Well, what's the,
he drives a big truck, interstate. The tether actually bothers him shifting the gears. I used to unload trucks, those truck drivers
why is it bothering him shifting the gears?
on his foot.
Well, it's on his ankle.
Yeah, on his ankle. You know, they got a clutch. It's not, okay. It's a big truck.
I know.
He got,
I-
there's not a single violation Stay away. Well,
I know. However, it is standard that we will have a GPS tether on. There is no stipulation. I'm not sure that there's not a medical reason, there's not anything else. It may be uncomfortable to have it on. I'm going to deny the request. The GPS tether will remain in place. What are we doing with the case?
need a prelim exam, Your Honor.
And maybe after the hearing, it can be addressed. All discovery is complete.
We're set to go.
People would have their witnesses available the 5th.
We'll do our best.
Preliminary examination in person, November 5th, 2024, 9 a.m. That will be before Judge Perry. Bond with its conditions will continue. Thank you.
Yeah. I might work.
Court calls the case, People versus Jarrell Childs.
And good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Childs. Mr. Childs, could you please state your name for the court?
You're seeking an adjournment.
Yes, Your Honor.
How much time were you looking for?
Hoping for 3 weeks, Your Honor.
Preliminary or probable cause conference, November 14th, 2024. 9 a.m. Bond continue. Thank you.
Thank you so much, Your Honor.
Court calls case of the People versus Edwin Emerald.
Ready, Your Honor. Your Honor, Joe Simon on behalf of Mr. Almiron. Edwin, state your name when you come up here.
My name is Edwin Amaral, Your Honor.
Thank you. You're requesting an adjournment on this matter. How much time did you need?
This one might need a little extra time, Your Honor. This is a investigation with Detective Babich, so we don't have dates yet. We're working on that. So about 4 weeks, Your Honor, if that's possible.
Pardon?
About 4 weeks, if that's possible.
Not objection. Probable cause November 21st, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Wait for me outside. Yep.
Court calls case People versus Casey Atkins.
Public defender appearing on behalf of Ms. Casey Atkins. Ms. Atkins, please state your name for the record.
Casey Atkins.
Thank you, Judge. My understanding is this matter was referred to a treatment court and that evaluation has not yet returned. We are asking for another.
Which court?
I believe a 14B recovery.
The evaluation hasn't been done yet.
No, Judge.
Does anybody have a time frame on when they'd get that done?
I am told that when she was here 2 weeks ago, they told her it might take 4 weeks. It got set for today, so I'm thinking 2 more weeks, which should be enough time, Your Honor. She says they did complete the evaluation.
Pardon?
They did complete the evaluation. We're
They just
waiting
haven't given an answer yet.
Correct.
Okay. Probable cause conference. November, well, let's go to 7th. Let's see if it'll work. November 7th.
Judge, if I might, I understand that Ms. Atkins asked you for a bond last time.
She did.
She's asking me to ask again, Your Honor.
Sure.
She's asking for release to treatment, if possible.
Once the assessment's done regarding the treatment court, then a lot of that will take place. I think I had indicated that the last time.
That's what I'm hearing, Your Honor. Yes.
November 7th, 2024, 9 a.m. Bond continued.
Thank you very much, Judge.
Court calls case People versus Alexis Archer.
Ready, Your Honor. Your Honor, good morning again. Joe Simon on behalf of Ms. Archer. Go ahead and state your name, please.
Alexis Archer.
I have a plea form. Is that what we're doing?
Yes, Your Honor.
The plea form indicates that the defendant would be pleading guilty to an added count 2 of larceny by conversion. It's going to be 200 to 1,000. That's a 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. There's a sentence agreement, although I could not find the judge to no upfront jail. And that defendant is approved for an extended HIDA. There's also, it appears this is indicating there's restitution agreed in the amount of $1,000.
All of that's accurate, Your Honor.
That's court's full understanding of the agreement. Ma'am, if you can please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, state your name again for the record.
Alexis Archer.
All right, ma'am, it is this court's understanding that you're going to plead guilty to the charge of larceny by conversion. That's a misdemeanor, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
Understanding all of that, do you still wish to plead guilty?
I do.
And to that charge, how do you plead?
I plead guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of rights.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No,
to
Your
court?
Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
October 17th, 2023, at the location of 2651 International Drive, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do involving the property of Tyler Thomas that makes you think that you're guilty?
Can I ask her a couple questions, Your Honor? Did you facilitate
Sure.
payment through your Apple Pay account for a fraudulent transaction for other people?
Yes, Your Honor.
That would,
I mean, yes, I did that once. Yeah.
She said, Your Honor, to me. That's what
I didn't mean.
it's okay. He pretends it.
No, no. And the amount was over $200.
Yes.
Yes, Your Honor, we're satisfied as well.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be December 5th, 2024, 10 a.m. before Judge Washington. Bond in this matter will continue. Thank you, ma'am.
Turns out there for me.
Court calls the case of the people versus Ardale Clark.
Assistant Public Defender Jay Bellinger on behalf of Mr. Ardale Clark Jr., who appears to my right. Mr. Ardale Clark Jr., can you please state your name for the record?
Ardale versus Clark Jr. Thank you. This is a waiver.
It is a waiver, Your Honor. We do
Sir.
have an agreement to an offer that I'll let Ms. Blanche put on the record if she'd like.
Go ahead. All right. Sir, you're going to waive your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following.
Thank you. We acknowledge receipt of information. Waive formal reading, stand mute, Your Honor.
Defendant having waived former reading, standing mute, court will enter not guilty plea. Pretrial will be set for November 5th, 2024, 1:30.
Thank you, Your Honor.
Thank you.
Is that okay?
Court calls the case of the people versus Ashton Gregory. That's Miss. Did you give it to Miss Blanche? Miss Blanche needs it.
Your Honor, Sam Bernstein with him on behalf of Mr. Gregory.
Good morning.
And I know there's a bond violation that we probably have to address first before the next stage, if the court would like to do that.
Yes, go ahead.
So it's for not making it to community corrections as referred, Your Honor. Mr. Gregory's had a very rough time once he got out of jail. He's an epileptic and he didn't have his seizure medication while in there, and his brain's been a little fried. He enlisted his mom's help when he got out after community corrections gave him a call, and she called a couple times but wasn't able to get through. So it's just been very.
Who called?
His mom called.
Called where? Community corrections?
Yes, after they called.
When
Mr.
did
Gregory.
that take place?
The day that he told her. And I talked to her this morning, last night. She said she left several messages.
When? Because it's not even reported on here. Ms. Mahoney,
The day that
go ahead.
he spoke with community corrections, Your Honor. That's what she told me. She called several times and tried to make contact.
That's not what this at all says.
Well, she left voicemails, Your Honor. I don't expect them to write down voicemails, but she was trying to help him. Hold on. When he got out of jail, he did not have his seizure medications. It was still at the jail. He's been having a very difficult time. He went to the hospital for almost a day because he was seizing. It's just been very difficult for him to get his affairs back on his feet after release, Your Honor. He tried to have his mom's help. He didn't quite get there. They went to community corrections this morning to try to rectify it. When I informed them about it last night, they said that he needed a new referral. I talked to him about what this all entails. He has absolutely no problems going to community corrections.
Go ahead. I'm listening to you, but I'm also looking at what's stated here. He said he needed to talk to his mother regarding the appointment, and we haven't heard from him.
Yes, sir. He did not go back to community corrections after that phone call. He tried to have his.
Why not?
I didn't understand where it was at or how to do it. I'm not gonna lie.
He scheduled an appointment. He telephoned them and scheduled his intake for October 17th.
Yes.
He failed to appear for that appointment. Where was he?
He was at home, Your Honor, with his mom. Like I said, he was having a very difficult time. He had spent time in the hospital after getting out of jail. He didn't have his patients because he can't re-up them after he leaves. And so he's been having seizures on and off. His brain's been fried. I know people with epilepsy, it's a thing where your brain gets fried to where you can't think straight. That's just the condition he's been in for the last.
They then called him and he stated he was suing as he was not given medication while jailed and could have had a seizure. Then he stated, according to this, he needed to talk to his mother regarding the appointment.
Right, Your Honor. And that's my
And then we haven't heard from him.
And he tells me, and I've spoken with his mom, that he told his mom that she was trying to help him through the issue. She
What
called
do you
Community
want?
Corrections.
There, is that his mother?
Yes, Your Honor.
The one waving at me?
I do believe so.
What is your name? What do you want to tell me?
Just on the, it was a father called and scheduled whatever. I didn't know anything about him having to report to the community, even though I was finding him out. Once I did hear from him stating that he was supposed to, I called several times and left messages just to come back to see exactly what was going on, because I didn't know. So with the lawyer yesterday about 3 p.m., he told me about the violation and what needed to go on. I let him know that I would take action to get scheduled and get what needs to happen.
He should have gone over there the first time.
That's correct.
I don't even hear a reason why he did.
We just didn't know what was
I
going
didn't
on.
know what to do.
You called them.
That wasn't me. I don't know nobody. I don't know what to do.
And as far as the seizure medication, we still weren't able to get that today. So he still does not.
The report I have indicated he called over and scheduled his intake for October 17th.
I didn't call nobody.
And your father didn't let you know that it was scheduled for that day?
Nobody did, sir. Nobody. I didn't call no one.
What are we doing on this case? I don't believe any of this, but go ahead.
Well, what I do, I guess, depends on what, I was begging for a second chance for him to get to community corrections. He can go there right now. I have good contact with him.
What are we doing with the case is my question.
I have a green form to ask for an adjournment, Your Honor.
Probable cause conference, October 31st, 2024, 9 a.m. At this time, I'll let his bond continue. I'm signing a referral right now. You need to go over once you leave here. You need to get over to community corrections and do the intake. Am I clear? Thank you. And what calls case? People versus Carlos Harris.
On Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Harris, who approaches the bench.
Good morning, Your Honor. Marcia Crater on behalf of Mr. Harris in 5-5.
So what are we doing?
So, Your Honor, you should have a green sheet requested. We don't have any discovery. I think he was very recently arraigned in this. So we didn't get the discovery.
And I'm asking for the adjournment of my matter to track along with the public defender's case. Your Honor.
Is your reason you didn't state anything?
Oh, to track along with the public defender's case, Your Honor.
Wants to hang out with us.
Sir, what is your date of birth?
7/14/91.
We got a dad with the same name. Not that uncommon in a you or somebody else.
We are wrong. So sorry.
I can go ahead. Thanks. And how much time, Mr. Brown, did you say you needed?
Just long enough for discovery, which I assume is going to be next available PCC.
Probable cause conference, October 31st.
21st.
Well, what is today?
No,
24th.
24th.
Actually, it's November 7th. I apologize. November 7th, 2024, 9 a.m.
Thank you. And we very briefly address the issue. So, Harris is here from Wayne County. Although the reason that the bond was set so high is because those matters are pending. Those have been resolved. We're asking that he be allowed not a PR, then some sort of, does have family issues, significant other, they have a child in common, and the significant other is sick, and to be there to take care of the child. So he's not asking necessarily for a PR bond unless you want to give him one. but a GPS, something to make sure the court knows where he is. He will return to all future court dates. Response?
What do you have the public defender's court file listed at?
Pardon?
What is the public defender's court file number?
The public defenders is 224F1300.
He's not held on that file, which is why I wanted to be there. He is
Got it.
held on agreement there, so I'll sit down.
Got it.
Well,
Thank you.
my bond argument would be the same. Okay. I believe Mr. Brown was for efficiency, making the bond argument for both cases.
Really?
Absolutely. He did a very fine job. I really have to compliment Mr.
Well, there's no need to address Mr. Brown's argument. He was giving me an Akinruli argument where the person is not held. That is the official name. That is so. Motion for bond reduction on both cases is denied. Bond continue in both cases. Thank you.
Thank you, Your Honor. Oh, yeah. Wait, hold on. Mr. Brown? Mr. Brown? Your Honor, I'm sorry. My client just informed us that he has court in Wayne County, I believe, to be sentenced on the Wayne County matter on the 7th.
On the 7th?
Yes. So we would need a different date, Your Honor, for telling us so we wouldn't,
I'll set this for the 14th. They'll get him down for sentencing and then bring him back, I guess.
thank you, Your Honor. Sir.
Court calls the case, People versus Tariq Lee.
Your Honor, Sam Bernstein with on behalf of Mr. Lee, who I see on the Zoom screen.
Please state your name, please.
Tariq Lee.
We're going to be waiving the preliminary exam.
Lee, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
The complaint that we're waiting on, does it say Ypsilanti Township or Salem Township?
Salem.
It should say let me make sure I'm reading this right. My office issued an amended complaint changing the location to Ypsilanti.
Okay, the only one I have is Salem Township. Any objection to that change?
No, Your Honor.
Well, how are they gonna do this? And how are they gonna do this if I change the information on this? Well, he's going up anyway, so it's not gonna matter to us. It's a 2 instead of a 14B. I'll amend the information. Preliminary examination having been waived, defendant is bound over to circuit court on both counts. On count 1 with 2 following.
Do we have any further reading, Your Honor? Mr. Lee stands mute.
Defendant every way, formal reading, standing mute, court will enter a not guilty plea to both counts. Pre-trial in this matter will be set for
December 10th at 1:30 before Judge Cummings.
December 10th, 2024, 1:30. Bond continued. Thank you. I don't know, Ms. Hughes, if you want to sign this one that I struck through or get a new one. It's up to you. Court does call the case. People versus Matthew Menke.
And Your Honor, Joe Simon, on behalf of Mr. Menke, state your name, Matthew.
Matthew Menke.
Your Honor, the parties are requesting a very brief adjournment, like maybe even just 1 week. There's some continuing discovery if that's possible, but may the parties approach very briefly to inform the court of one thing.
Fine.
Oh, I didn't say. We're going to go down with the plan. But and Your Honor, thank you. We're back on the record requesting an adjournment of the PCC. I also informed the court, that my client's father is trying to arrange with it through insurance, et cetera, his acceptance into an inpatient treatment program. I made indications to the court and the prosecutor that if that can happen, I'll be seeking to present a stipulated order on the terms that the parties can agree to that effect to allow his release to such a program.
Correct. And so what I'll do is I'll adjourn it to November 7th, 2024, 9 a.m. By putting it out that time frame, it can work to try to get him into inpatient, but it won't interfere with that because we could come back next week and it not quite be done. So we'll do it this way. And if it's done by step, it'll happen anyway. Okay. Thank you.
Thank you.
Simon, I don't care what you say. It's not you. Court calls the case. People versus Nanny Wesley. It's upsetting.
Your Honor, Sam Bernstein with on behalf of Ms. Wesley.
Who was on the people's? Who? Oh. All right. Thank you.
We wish to waive the preliminary exam.
Thank you.
And we wish to waive the preliminary exam, Your Honor. There should be a waiver form in your file.
I do have one. Mayor, is that correct?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the preliminary examination, having been waived, defendant is bound over circuit court on count 1 with 2 following.
Your Honor, please waive any further reading. Acknowledge receipt of the information. Stands mute.
Defendant may waive formal reading, standing mute. Court will enter not guilty plea to both counts. Pretrial will be set for
December 10th at 1:30 p.m. with Judge Conkey.
December 10th, 2024, 1:30.
Thank you, Your Honor.
Bond continued with its conditions. Thank you. I knew you would ask that, and I don't have one. All right. Okay. Court calls the case, People versus Ahmet. Is it Enright?
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Aaron Wright. Mr. Aaron Wright, please state your name for the record.
Good morning. I just wish to mention for the record that earlier this month, I mailed 2 letters, one to the prosecution and one to the attention of the judge. And my name is Amit Ehrenreich.
Your Honor, as the court knows, this matter has been out for competency. We have not yet received a report. I've spoken with the prosecution. I don't believe they have one.
I don't have a report either. So I will adjourn the competency hearing out. I usually put it out 30 days. Put it out to, what's mine? Is it 26?
Yes.
November 26, 2024, 9 a.m. Bond will continue. It should be noted that there were indeed letters sent to the court. They're in the file if you did not get a copy. They were written on napkins. So we did not 2-hole punch them. They're in the envelope here.
I was not on the Christmas card mailing list. I did not get a copy. So I will be happy.
We'll be more than happy to share the napkin with you. Don't wipe your mouth with it, please. Thank you.
Thank you.
You're welcome, sir. Court calls the case. People versus Kenneth Herndon.
Good morning, Your Honor. Edward Dukes on behalf of Kenneth Herndon.
Kenneth Herndon.
Thank you. You're requesting an adjournment?
Yes, Your Honor. I'd ask for 3 weeks.
Why 3?
2 is a conflict, 1's too short.
Probable cause conference, November 14th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
You're all set. Court does call the case. People versus Donald Grandal.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Grandal in case 1385.
Kyle Verdell also on behalf of Mr. Randall in case number ending at 5644.
Yes.
Right, Judge.
And Your Honor, we are asking that this be set for a preliminary examination.
All discovery is complete.
Yes, Your Honor.
Your Honor, I've received the video and the paper discovery. I believe there is 911 calls, which I would request at this time, but that shouldn't be a problem getting to me in time.
Which case are you on?
I'm in the case ending in 5644, the FA.
People have their witnesses available the 5th. Preliminary examination, November 5th, 2024, 9 a.m. That is before Judge Washington in both matters. Sure.
This Apple today or this morning. So that's a privilege.
Any response?
No, Your Honor, I did receive the 2 phone calls. Was that all, Ms. Blanche, that there was?
That's all I had that
Okay.
he was saying. It's up for her to whether or not this case moves forward. So we have
Okay.
phone calls, but I will release any other ones if we have some.
Okay. Thank you. And no response. Thank you.
Your Honor, I would just ask that perhaps you could block the complainant's number in that matter rather than revoking his phone privileges entirely. But ultimately, I'll move to the court's discretion.
Defendant's phone privileges are hereby ordered revoked pending any hearing or request by the defense.
Thank you, Your Honor.
Thank you. Case People versus James Johnson.
Morning, Your Honor. Edward Dukes on behalf of James Johnson and.
No, I didn't expect him to come out that door. I did.
And Assistant Public Defender Lamisa on behalf of Mr. James Johnson on the case ending in 1350.
I've submitted in my case an adjournment form. There's some still outstanding video that I need to obtain. Asking for 3.
I'm sorry.
I've also submitted a green sheet for an adjournment so that we can follow suit with Mr. Drukas and have the cases back.
That clear for probable cause conference will be then adjourned to November 14th. 2024, 9 a.m. Bond on these matters will continue.
Thank you.
Thank you.
Please
Going Grandall's files. Is that Grandall?
Yeah.
Oh, here they are. Okay. Court calls the case People versus Frank Green.
Overwater Assistant Public Defender on behalf of Mr. Green.
On behalf of Mr. Green on case ending in 5259. You want to sign this? Waive every right.
Mr. Green's already been accepted into felony drug court on other matters. We'll be waiving both of these matters to circuit court. We're going to turn to-
Your Honor, I was just appointed yesterday. I met with Mr. Green last night. He's fully aware of his rights to have an exam. We explained it to him. I explained to him last night. We're waiving that, Your Honor. And the goal is to get this man into drug court, Judge.
Is that correct, sir? You're waiving your right to preliminary examination?
Yes, sir. I did.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on the single count in each case.
Judge, we acknowledge, receive the information, waive its reading. My client will stand mute.
We'll do the same, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set in these matters for
December 10th at 1:30 before Judge Conti.
December 10th, 2024, 1:30.
Thank Judge.
Thank you, Judge Simpson.
And we'll continue in this case. And court does call the case People versus Sheldon Vermette.
Your Honor, Michael Vincent on behalf of Sheldon Brumett. State your name, please.
Sheldon Brummett.
Brumett. And he's waiving his right to a preliminary examination.
That's correct, Your Honor.
Sir, is that correct?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was the offenses alleged were committed and that you committed them.
Yes.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive the right.
Yes, Your Honor, thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count in each case.
Thank you, Your Honor.
You got to do the other part. Oh, you're acting.
I thought you were waiting.
No, I know, but
Well, okay.
yeah, I know you were done, but
No, I thought you were done.
no, I was done. I walked in, but that's okay. Knowledge receipt of the information.
Yes, waive reading of it. He stands mute to the charges on
Defendant,
both cases.
it wasn't that hard. Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial in these matters will be set for
December 5th at 1:30 before Judge Slate Thursday.
December 5th, 2024, 1:30, Slate Thursday.
This is Amanda's fault, by the way, for not.
No, Amanda was telling you to go back. She was telling you don't leave yet, but you didn't listen as usual. All right. Now you may go. Thank you. Court calls case People versus Charles Peltier Turner.
Your Honor, Michael Vincent on behalf of Mr. Pelletier Turner. State your name for the judge.
Yes, Your Honor, my name is Charles Ansel Pelletier Turner.
Your Honor, may counsel and I approach the bench for a brief.
Okay, come on.
Oh, it's the first time I've asked all day.
I know, but it's going to take a minute. Record should reflect you had a bench conference in this case. Discovery is complete in this matter and defendants requesting a preliminary examination. Would the people be available and have their witnesses available on the 5th? All right. Preliminary examination in person, November 5th, 2024, 9 a.m. before Judge Perry. Bond will continue. Thank you.
And Your Honor, just for the record, I did make a bond request on this.
You did, and I am denying that request.
All right.
So bond will continue. Thank you. Court calls the case People versus Camus Carter.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Camus Carter, is to my right.
Name?
Carter.
I know. All right.
You sure, Judge?
Yeah.
Okay, all right. All right. No lineup necessary, Your Honor?
No, he's here more than my staff is. All right.
We're setting the exam, Your Honor.
Discovery is complete.
Yes, sure.
And with the people who have their witnesses available, the 5th. Preliminary examination, November 5th, 2024, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Bond will continue. Court calls the case People versus Brian Haggard.
Assistant Public Defender Louise Saab on behalf of Mr. Haggard. Mr. Haggard, please state your name for the record.
Brian Allen Haggard.
All right. The complaint has, this is count two.
Yes, Your Honor.
Oh, got it. It's covering up count one. All right.
We did have a chance to go over the amended complaint. We would waive formal reading and stand mute.
All right. Defendant naming way from a reading standing mute. Court will enter not guilty. Yes, to count. All right. What are we doing?
Your Honor, we are waiving preliminary exam in this matter, and I did submit the waiver form with Mr. Haggard's signature.
Is that correct? So you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I did, Your Honor.
And you understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Correct, Your Honor.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of the information, waive formal reading and stand mute.
Defendant in every way, formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for November 7th, 2024, 1:30 Slate Thursday.
Your Honor, if I may, if you would consider a release to treatment for Mr. Haggard, he would really appreciate it.
Yes, I will. Defendant may be released to inpatient treatment.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Phyllis Lindblade. Wow.
How are you, Your Honor?
I don't know. You disappeared for like ages.
You know who I blame. She's head of our office, so I
Who?
want to talk to her about it.
Who?
Ms. Simpson.
You're going to talk to her about that?
I'm gonna talk to her about it, yes.
Okay. Let me know how that goes.
I will. I will.
I'm going to suggest you don't, but go ahead.
Your Honor, Ms. Lindblade is not present. She called me yesterday. She is in the Regency, St. Joe's Regency Rehab Center for medical issues. She was experiencing chest pains, shortness of breath. And our conversation was exceptionally brief. She is just asking for a 2-week adjournment so that she can be present.
Any objection from the people?
No, thank you.
Probable cause conference will be adjourned November 7th, 2024, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Michael Hathcock. 2 cases. Oh, they gave you more than 1 case?
Yeah.
Wow.
She really wanted us to enjoy our time together. Stephanie
Okay.
Cannon with the Public Defender's Office on behalf of Mr. Haycock, who's appearing to my right. Please state your name for the record.
Michael Hathcock.
Thank you.
Your Honor, we are going to ask that you set these matters for a preliminary exam.
File discovery complete on both cases.
Your Honor, based on my review of the file, it does appear so, yes.
Wow. That was pretty fancy how she. People have their witnesses available on the 5th. Preliminary examination in person, November 5th, 2024, 9 a.m. That is before Judge Perry in both matters.
Thank you, Your Honor.
Bond will continue. Thank you.
You have, sir, did you have